we will present to you about our topic inside of our infographic, which is Judicial Review of Executive Discretion. And I am honored to share with you guys about the first introduction of our topic in today's presentation. So we have take a part of newspaper, which is court can review proclamation of emergency, says ex-Attorney General Tommy Thomas, and the newspaper was dated on Saturday, 24 October 2020. So what does Tommy Thomas says? He said that in his opinion, a proclamation of emergency in present circumstances is justifiable before our court. He said in a statement countering the view of several politicians who were in favour of an emergency being declared ostensibly to fight the third wave of COVID-19 and the subsequent economic gloom. So in this issue today, we know that the proclamation of emergency was under the jurisdiction of YDPA, and YDPA is part of the executive. So why does Tommy Thomas say that the court can review proclamation of emergency? In general, in the federal government, executive consists of YDPA, Conference of Rulers, Prime Minister, Cabinet, and Public Services. So what does executive do? So executive governs the country according to the laws made by parliament. So we will go one by one and in details in further discussion. Now let's go first about the doctrine of separation of powers. The doctrine of separation of powers is a political doctrine under which the legislative, executive and judicial branches of government are kept distinct to prevent abuse of power. However, Malaysia has its own model. Whilst our constitution does have the features that separate the power, it also contains features which do not strictly comply with the doctrine. So to what extent the doctrine applies, therefore, depends on the provisions of the Constitution. So we want to know about our issue here, which is whether there is the limit to executive discretion, right? So let's look at Article 39 of Federal Constitution that confers about the executive authority of federation. So what does the Federal Constitution says here? By virtue of Article 39 of Federal Constitution, it says that the executive authority of the Federation shall be vested in the Yang di-Pertuan Agong and accessible subject to the provisions of any federal law and of the second schedule by him or by the Cabinet or any minister authorized by the Cabinet, but Parliament may by law confer executive functions on other person. Therefore, here we will have a clear guideline which power have the Federal Constitution give to executive. Now let's move on to the example of case. Okay, now we will discuss about the case of public prosecutor against Kok Wah Kuan reported in 2007. So this case exactly define the true meaning of separation of power between judiciary and executive. In this case, it dealt with a child who was convicted of killing his tuition teacher's daughter. So he was ordered to be detained at the pleasure of the Yang di-Pertuan Agong, pursuant to Section 97 Clause 2 of the Child Act 2001. So the question that arose was whether his sentence was unconstitutional because it gave to the executive branch of government the function of the judicial branch of government, namely the determining of the sentence, which means that in this section it gave the power to determine the sentence to the executive branch rather than the judiciary branch. So hence the issue of the existence and applicability of the doctrine of separation of powers within the Malaysian Federal Constitution. So this is one of the cases that have been in relation with the judicial review of executive discretion. So now in my friend's explanation, there will be a lot of other cases that we will provide it to look into what does the judicial review have about the executive discretion. Thank you.
The first case is Sis Forum Malaysia against Datuk Seri Syed Hamid bin Syed Jaafar Albah, Menteri Dalam Negeri. Okay, in the case of Sis Forum or Sister in Islam, which is known as the famous Muslim Women's Group, they sought judicial review of the Home Minister's decision to ban their book with title Muslim Women and the Challenges of Islamic Extremism. Okay, the book was banned by the minister who purported to act under Section 7 Clause 1 of the Printing Presses and Publication Act 1984, whereas the book was published in 2005 and was sold peaceably for over 2 years until it was banned by the minister. If the minister is satisfied that any publication contain anything which is biased to public order, morality, security, public interest or national interest, or which is contrary to any law or is likely to alarm public opinion, he may in his absolute discretion prohibit that and any future publication by the publisher. The issue is whether the supporting reasons provided by minister is acceptable by law and whether book could confuse Muslim. Okay, in a most significant ruling, Justice Arif also held that objection and fears of organization like JAKIM that the book would confuse some Muslim women was not an adequate ground to exercise powers under the Act. The minister must bring the case under permitted ground of public order. On the totality of the fact, the judge was not satisfied that any threat to public order was proved. The book had been in circulation for 2 years, and there are passages in just 7 out of 215 pages that individual had protested, and no issue had come about for the 2 years. Okay, and the last issue is whether the minister's decision illegal and wholly disproportionate. Okay, the administrative law principle of proportionality was also employed. The minister's reaction to the offending passages was wholly disproportionate to the concern expressed and was vitiated by the administrative law principle of illegality and irrationality. All absolute discretion are an affront to Article 10 of Federal Constitution, guarantee of free speech and Article 8 of Federal Constitution, promise of equality. And the grounds on which the Printing Presses Act permits the minister to ban free speech are wider than those permitted by the Constitution. In the exercise of his discretion, the minister is entitled to consult anyone to consider all points of view, but he is not allowed to abdicate his responsibility and pass his legal power to others to act on it. And the decision made by court is judicial review application is allowed with cause.
Assalamualaikum. For the next cases related to our topic is Merdeka University Berhad against Government of Malaysia. The facts of the case, the plaintiff, a company limited by guarantee, submitted a petition to the Yang di-Pertuan Agong for an incorporation order for Merdeka University under Section 6 of the Universities and University Colleges Act 1971. But the petition was rejected, and the Minister of Education announced that the rejection of the plaintiff's petition was for the following reasons. First, Merdeka University would use Chinese as the medium for instruction. Second, it is meant to cater for students from Chinese independent secondary schools. Third, it is to be set up by private sector as a composite for the basis of rejection. that in effect its establishment would be contrary to the national education policy. Then the plaintiff requested a dialogue with the minister, but there was no response. Then the plaintiff issued a writ asking for a declaration that the rejection of the petition for the establishment of the Merdeka University is null and void, as it contravenes the federal constitution, and for a declaration that the refusal of the petition to establish the university is an unreasonable and improper exercise of the discretion conferred by Section 6 of the Universities and University Colleges Act 1971. So the issue is whether university is a public authority within the definition of the federal constitution. The provisions used in this case is Section 6 of the Universities and the University Colleges Act 1971 that stated, if the Yang di-Pertuan Agong is satisfied that it is expedient in the national interest that a university should be established, he may by order first declare that there shall be established a higher educational institution having the status of a university, which shall be a body corporate for the purpose of providing, promoting and developing higher education in all such branches of learning as shall be specified in the order. Second, assign a name and style to that university and specify the location of the site which shall be the seat of that university. Other article used is Article 40, Clause 1, Article 152, Clause 1, Clause 6, and Article 160 of Federal Constitution. So the judge decided that the claim dismissed with cause because there was sufficient basis for the YDPA to be satisfied on anyone that it was not expedient in the national interest for Merdeka University to be established. I think that's all from me. Thank you.
Assalamualaikum warahmatullahi wabarakatuh. Now we move on to the third case of our topic, which is called Dharma Surya bin Wisman Saleh against Menteri Dalam Negeri Malaysia and others. So let me talk briefly about the fact of the case here. The appellant was arrested under the emergency ordinance. He was involved in smuggling of stolen cars out of Malaysia. So the minister, one of the defendant, applied the ordinance for him so that he can be detained for 2 years. So the appellant, the perpetrator of this case, then applied for habeas corpus, but the High Court declined him, and so he appealed here. So the issue in the federal court is whether the act of smuggling stolen cars is prejudicial to public order, as exactly with what the minister had claimed. The federal court decided that High Court was correct and that he was to decline the habeas corpus and dismiss the appeal. So, aligned with our topic, the minister's opinion on the act of the smuggling and that it will disrupt the public order is not exclusive. It was justiciable. The judiciary has it on hand to decide and has a final verdict. It was not enough if the minister thought that he had reasonable ground to be satisfied and that the appellant had acted in a manner prejudicial to public order. The question that a court must ask itself was whether a reasonable minister, apprised of the material set out in the statement of facts, objectively can be satisfied that the action of the appellant were prejudicial to public order. What the court can do is try to examine what is the definition of public order, can it be applied here, and what was the precedent cases. So one of the judges of the federal court here, the prominent judge Gopal Sriram, had quoted this. The minister orders made it clear that he directed the detention of the appellant with his view to prevent him from acting in a manner prejudicial to public order. So the judge explained that yes, the minister had his own opinion of the smuggling and that it can detain him from being prejudicial to public order. He continued, in a gist, the statement of facts on which the minister based his order recite that the appellant was involved in the smuggling of stolen cars out of Malaysia. So minister had a base of fact that yes, the appellant was actually involved in the smuggling. Then, the statement considered to particular of dates and places where the appellant carried out his activity. So the statement actually aligned proportional to the places and that is actually where the appellant carried out his activity. The only issue before the High Court and before the Federal Court is whether the minister acted lawfully in classifying the activity of the smuggling by the appellant is alleged to be involved as constituting an act prejudicial to public order. In order to deal with these issues, they address to the way in which Section 4 Clause 1 of the Ordinance is constructed.